Good morning, sir. Can you see and hear me?
Yes, thank you. Yeah.
Thank you very much. Good morning, Mr. Singh.
Good morning. Good morning.
Can we pick up where we left off yesterday, which was examining issues in the general sense on the process and the procedure for prosecuting suspected offenders? Did you ever advise the Post Office to pursue a prosecution to act as a deterrent to other sub-postmasters from committing crimes?
How do you mean? Sorry, can you flash it out a little bit so I can? From my no.
Putting it another way, was the aim of deterring other potential offenders a relevant consideration in deciding whether to prosecute a sub-postmaster?
I don't think so. No. When I advised, no.
And why do you think no?
Because you're working on the merits and the evidence before you on that particular case. You're concentrating on what's before you. You're not sort of looking beyond anything beyond that.
Okay, can we look, please, at poll 00107869, please? And if we just look at the email at the bottom of the page, thanks. Thank you. And just if we scroll up so you can see who it's from and to. It's from you to Mr. Scott. And it's essentially your advice on a charging decision, as I'm going to call it, for Christine Gourlay in Scotland. And you say, I've read the file and having reviewed the papers, in my opinion, there is both sufficient evidence to provide a realistic prospect of conviction of Mrs. Gourlay, and it's also in the public interest to prosecute her. Do you see that?
Yes.
And then over the following pages, there's an analysis of the allegations, the evidence, possible defences, and the like. And if we can turn to page 4, please. And look at the bottom, please. Thank you. And just to scroll down a little more. Thank you. Under conclusion, paragraph 28, you say, in my opinion, because of the above evidence and matters, there's sufficient evidence to provide a realistic prospect of conviction of Mrs. Gourlay. In my opinion, it is in the public interest to prosecute Mrs. Gourlay because of breach of trust and the large amount of loss. And then prosecution and conviction will act as a deterrent to others. And Mrs. Gourlay, in her interview, is implicitly attempting to blame innocent parties. So it's the part of the sentence there which says prosecution and conviction will act as a deterrent to others. That tends to suggest that in deciding whether to prosecute or not, you did take into account the possible deterrent effect of a prosecution and perhaps conviction upon others. Would you agree?
Firstly, it's such a long time ago. I don't know the full details. I would have read the files in depth, considered it, maybe in general terms, but not the main ones are. The fact is there's evidence. The public interest is the breach of trust. There's a large amount of loss.
I'm not asking you about those. I'm asking you about the bit of the reasoning which says prosecution and conviction will act as a deterrent to others.
But that, maybe just complete the sentence or something, but it wouldn't be. To be honest, that's never actually gone through. It's not the process I would follow. I don't know why, in these circumstances where there was something in the in the investigation officer's report or in the interview or something that John Scott, I think, specifically asked me to consider. But in general terms,
No, he didn't.
that wasn't not the aim. It's certainly, I accept the fact it's here, yes, but it's not the main. It's never been the main consideration in any of my advices or in my consideration. For some reason, it's there because it's peculiar to these details that's in this particular case. I don't know whether he's particularly asked or the investigation officer asked or he asked me to address it. But yes, it's there.
In the documents that we've got, the investigation report and the other communication from Mr. Scott, he doesn't ask you, please can you include in your advice whether or not prosecution and conviction will act as a deterrent to others, and please include one way or the other in your reasoning whether you take into account or leave out of account the possible deterrent effect. It's something that comes from you and not him.
Yes, but maybe then it's such a long time ago. I don't know, maybe on that particular day, but certainly generally I wouldn't have. The other advices you've probably seen it's not there.
Was this a...
Can I just interrupt? I don't think this document's been provided to Singapore.
So the solicitor has said... Sorry, sir, you won't be able to hear because the... hold on. Mr. Singh's solicitor has just said, I'm sorry, I don't think this document was provided before. I'll check whether that's so, and if Mr. Singh needs any time at all to read it, he should have it.
I agree.
Thank you.
Do you need time to read this document?
Is that the only? Have you got quite a bit of papers from you?
I'm sorry.
Have you got quite a bit of papers to go the background to it? So can I have as much as information you've got?
I can certainly research that and come back to you later in the day or when you come back next year. If that would assist. I don't know at the moment whether this was a document that was provided or not. I can just check, however. Yeah. Yes, it was part of the batch of documents that was provided last week. It's tab E92. So you have had it before. I'll move on. Were cautions an available outcome? That can come down.
Sorry?
Were cautions an available outcome?
Yes, I think yesterday we discussed it, yes.
Was there a statutory basis for the Post Office issuing cautions to suspected offenders?
I'm sorry, I don't understand. I mean, the normal... What do you mean statutory? It's something that we considered, yes. I mean, after the evidence, the next bit is whether there's an alternative way of dealing with it, and in light of the public interest.
Where did the power come from for the Post Office to issue a caution?
Certainly we advised as to how it's given, who gives the caution, whether the police does it for the Post Office or the police got any statutory powers. I don't know. I can't. I mean, maybe at that time I did know, but what the system was or what the procedure was or what the basis was, certainly we did advise on cautions. I think in every single case we considered it's always, the evidential test and then the public interest. And public interest, one of them was the fact there was alternative ways of dealing with it rather than, prosecution.
And so was this a consistent practice over the entirety of the period that we're talking about, from August 1995 until, say, April 2012?
You mean the consideration for caution?
Yeah.
Certainly on my cases, I had a checklist of going through it. And first the evidential test, then the public interest, and there was the alternative way of disposing it, without resorting to prosecution. But then a lot of the time, majority of the time, is the breach of trust and the amount of loss involved, or amount of loss.
Was there a Post Office policy which regulated when and in what circumstances cautions should be offered to suspected offenders?
I think we basically applied the prosecutor's code. If it's in there, then certainly, but certainly.
The Code for Crown Prosecutors.
Yeah, sorry.
That doesn't address cautions.
But then, but certainly, that's maybe in our training or the way we looked at the case, we certainly considered it. I mean,
What were the relevant considerations in deciding whether to offer a suspected offender a caution?
Well, in any circumstances, in the sense that the amount involved, the recovery.
Sorry, the amount involved.
Yeah.
So what was a permissible level of amount involved for a caution and what was an impermissible amount?
I wouldn't, but it depends on the circumstances, the whole circumstance of the case. But I think around about 5,000, I think is the figure of 5,000 comes to mind.
So what, if it was below that amount, then
I
a
think
caution was permissible, is that right?
I think there was no strict figure, but that was the figure I think the figure they mentioned that we ought to pay more attention to.
The next thing you said and the recovery. What does the recovery
mean? If it was a short period of offending, or it was just one-off offence, or the circumstances around it, persons, the health issues, or the personal persons.
No, you're talking about different things now. So I was asking about the thing you just mentioned, which was you said and the recovery.
Well,
what did that mean?
Money, if the money's repaid, that's what it means.
Was that a condition of issuing a
caution? No, there's no condition. It's a consideration. That's the sort of.
What was a consideration?
The amount lost and the amount recovered. I think that was one of the bases of.
So had the amount had to have been recovered in order to issue a caution?
To be honest, this is going back a few years. Or lots of years, number of years. I've been doing other things. Now I don't know. You probably put me on the spot, so I can't give you a definitive answer on that. But certainly it was considered. I think any case I dealt with is I always played my mind to it.
You went on to mention health. Is that the health of the suspected offender?
I think and the family. I think any surrounding circumstances, anything and everything.
Were there any other considerations brought into account? You said the amount of the loss, whether it had been recovered, i.e. whether the postmaster had paid it back, and the health of the suspect and their family. In addition to those three things, was anything else brought into account?
I don't know. I mean, I can't give you a definitive answer because it's such a long time ago since I left the post office and left there. The prosecution. Prosecution. Generally, I've been doing other things, as you know. I don't know the answer to that.
What about an admission?
Well, obviously
of guilt by the offender, which in the outside world, outside the post office, is.
Full and frank.
A condition precedent to the issuing of a
full and frank
caution.
Admissions. Yes. Well, that is one of it, isn't it? Yeah.
Is that a fourth thing then?
Well, yes, it's important. Yes, it's got to be, hasn't it?
And can you remember any guidance or written document that told you and the other senior lawyers how to approach this issue?
I think it's certainly, I don't know about internal document or internal training now, but certainly the outside training, we had the central law training. I certainly regularly attended. There was the training.
Was that training about cautions?
Well, some of the trainings were about cautions, yes.
So you received training from central law, did you say?
It's central law training, where you get your CPD points each and every year.
That was training about cautions?
Well, one of the topics would have been, I would have thought, I mean, I can't tell you which one, And then certainly Chambers, I think, did quite a lot of training, whether it was on caution, but certainly on the subjects we were sort of interested in. I don't know whether that somebody mentioned it and they applied, they trained us on that, or what sort of considerations that go in it. But such a long time ago. But there was a lot of training, but I don't know whether it was actually a post-office manual we applied to. I mean, whether it was written down internally, I can't really say one way or the other whether it was or not.
Was there a process that had to be gone through for the authorising of caution?
Well, that's something we advised on or recommended, but as to how it's applied, I couldn't tell you. It's such a long time ago as to how they did it, but I think it's certainly the security or the investigation team carried that out. They're the ones who carried it forward as to how they administered it, whether they had the authority.
Never mind the administering of it at the moment. I'm thinking about who decided that a caution was appropriate.
Well, it was obviously the legal team. I think
You were the decision makers.
we recommended it. We didn't make the decision. We recommended
Okay, to whom did you recommend it?
to the security team. We passed it to the prosecution support office, and who in turn, I think, passed it on to the decision maker or the designated decision maker, I think.
And would that designated decision maker have changed over time? Sometimes it being somebody in HR, I believe, and then it changed to being the head of security.
It was yes, I think it probably did. But what I'm saying is that we went to the prosecution support office. They in turn passed it on to the appropriate person, whoever was the designated authority at that particular moment in time.
And so, as matters stand now, you can't help us with the power that the Post Office used to issue cautions to offenders, nor whether there existed guidelines regulating the circumstances in which such a caution could be issued.
I'm trying to think. The practicality of it. I mean, it's just too long a period between when I was advising on it and since I left. I can't. No, I don't think I can help you with any more than what I have.
Thank you. Can I ask you some questions about the duties of a prosecutor in relation to an expert witness? Do you agree that a prosecutor intending to rely on expert evidence in criminal proceedings was under the following duties? Firstly, to satisfy themselves as to the expert's relevant qualifications and expertise.
Sorry, you finished. Sorry. Yes. Yeah. Are you going to read I think you're going to read the whole thing, or are you?
Well, I could read out 6 things, and then you'd have to remember them.
Oh, okay.
And say which of them you agreed and which you didn't. It might be best if I did them
okay.
one by one.
One by. Sorry. Yes.
So that's the first one.
Can you say it again? Sorry.
Do you agree that a prosecutor was under a duty, if they intended to rely on expert evidence, to satisfy themselves as to the expert's relevant qualifications and experience?
Yes. Yes.
Secondly, a prosecutor was required to satisfy themselves that the expert had been appropriately instructed, including by the provision of a written and detailed letter or email of instruction or terms of reference.
Yes. Yes.
Thirdly, the prosecutor was under a duty to provide the expert within those instructions as to what it is that his or her opinion was sought about, and should set out the issues or questions that they were expecting the expert to answer.
Generally, yes.
Fourthly, they were under a duty to provide explicit guidance as to what the expert was being asked to do and what material they were being asked to consider in order to undertake that task?
Yes, yes,
Fifthly, a prosecutor was under a duty to set out the material upon which reliance had been placed in the prosecution and which of that material may be relevant to the questions which the expert was being expected to answer.
yes,
And sixthly, a prosecutor was under a duty to inform the expert as to the expert's relevant duties.
yes,
Would you agree that even those experts who were trained, accustomed, and made their living by giving expert evidence, a prosecutor had to make the expert sure that they understood what the expert's duties and obligations were?
yes, yes,
Would you agree that there was a duty on a prosecutor to satisfy themselves that the expert had understood that they owed duties to the court and that in their work and their report they had complied with their duties to the court?
yes, 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 of course.
Would you agree that a prosecutor at all relevant times was under a duty to satisfy themselves that any material or literature of which the prosecutor was aware and which might undermine the expert's opinion was reviewed by the prosecution and, if relevant, disclosed to the expert?
Yes,
And would you agree that these duties needed to be satisfied in order that the prosecutor could be satisfied that the expert evidence was admissible in court, i.e. these were conditions of admissibility rather than just written requirements that it was nice to achieve?
yes, yes,
So these went to admissibility.
yes, I agree.
Did you, in your work, have all of those duties in mind when you were advising on files and acting as a prosecutor?
I'm trying to think. I don't, apart from one case, which again, I've never instructed an expert in any of my cases
In the
post office.
post office, you never instructed an expert?
No,
Never relied on expert evidence,
no.
including in Seema Misra's case?
Well, that again, I think you've seen my witness statement.
You say you didn't treat him as an expert. It was the court that did it.
No, I'm not saying anything. All I said was that he came as the only person who could assist with the workings and operation of the Horizon system. And I think as the matter progressed, it became apparent that the only way the defence experts can function or able to do his duties or advise or assist the court was with the assistance of the guy who was assistant of the Fujitsu employee who knew the system very well, because it's a very, very specialist system. So you need a special knowledge. You can't just have anybody come in to be able to understand it and then actually assist the court.
We're going to come back to that big topic in a moment, whether you treated Mr. Jenkins as an expert
Yes, of course.
or
Yeah.
not.
Yes.
Would you agree that in terms of inclusions in an expert report, that by 2006 the following matters were necessary inclusions in an expert report? Firstly, details of the expert's academic and professional qualifications, experience and accreditation, insofar as they're relevant to the opinions expressed in the report.
It's something that I think we very much heavily would have relied on advice from counsel. Certainly, I think that's as far as I can take it, because that the only time when I think you said you're going to come to that topic in a minute. That's one of the reasons why we relied very heavily on counsel, because we used their vast experience in other cases, not just the post office cases, but outside, because a lot of our counsel were very experienced and knowledgeable about prosecuting for the CPS and other bodies.
I'm asking you whether you knew yourself that certainly by 2006 an expert report needed to include details of the expert's academic and professional qualifications, their experience and accreditation that was relevant to the opinions expressed in the report.
But I would have thought that was obvious. Yes.
So yes, you did.
I did, but as to the, I've instructed, I think, experts in the civil matters, but certainly in the criminal matters, that was the first experience of it, I think, and I've never even had a defence expert's report on any of my cases.
So Professor McLachlan, he wasn't an expert.
Well, no, but I think we're not talking about that yet. You said you were coming to it, but certainly I've saw his reports over and over again. But you're talking about in general terms, aren't you? Or are you saying?
I'm asking you whether you knew that both the common law and the Civil Procedure Rules, Part 33, which came into effect in November 2006, said that an expert report had to contain details of an expert's academic and professional qualifications, their experience and their accreditation, insofar as it was relevant to the to the evidence that they were going to give.
Before you answer, Mr. Singh, I think, Mr. Beer, there was a slip of the tongue. You said civil rules. Did you mean criminal rules?
I meant the Criminal Procedure Rules, yes. Thank you, sir.
I think I generally read about it, like I said, and also I did read the defence experts' reports. Certainly was all there. As to whether that was something of a second nature to me, I would say no, purely because I've never had a case where I had to instruct an expert in the criminal proceedings.
Did you know that by that time, 2006, the law required a report to include a statement of the range and extent of the expertise of the expert and any limitations that they identified as to their expertise?
I don't know. I mean, I'm trying to think what I knew at that year, the time period I was employed by the post office. But certainly, if I was instructing an agent, instructing an expert, I would have done a research around it as to what my obligations were.
Did you know that by that time the law required an expert report to contain a statement setting out a substance of the instructions that the expert had received the questions upon which their opinion was sought, the materials that they had been provided, the documents, statements, evidence, information, and assumptions which were material to the opinions expressed within the report.
In general terms, but then if I was going to instruct an expert, then I would have had a conference or got advice from counsel, read around the topic. But as to the knowledge, it's not something I would have retained readily. I mean, like any new experience or anything I would have done, which I've not done before, certainly I've read around it, got to know it very well, and then had probably sought counsel's advice before doing it. But it's as to, I don't know what you're asking in I knew, obviously in general terms, I probably knew quite a lot, but when it actually come to specifics, then I would have sat down and worked it out, and then sought advice, and maybe sought advice from other experienced lawyers within the criminal law team. And I think I would have gone to, the head of criminal law team to say, look, this is what I'm doing. Is there any pointers I need to know? And then I would have directed my mind to it. And certainly before embarking on anything of that nature, that's my background experience and reading around it. And then going to counsel, that's what we would do.
Did you know that by 2006 the law required a report where there was a range of opinion in the matters dealt with by the expert to include a summary of the range of opinion and the reasons for the opinion given by the expert within that range?
I don't know. I wouldn't know anything like that to that detail. I can't say one way or the other, but certainly if I was going to instruct an agent, instruct an expert, then I would have been able to bring my knowledge up to date to that level. But I mean, it's not something I would have retained because it's not something I would use on a daily basis.
Did you know that by 2006 an expert report was required by the law to include relevant extracts of literature or other material that may be of assistance to the court?
Again, same answer. I would have, if I was going to instruct an expert, that's what I would have done, and certainly I would have backup of a opinion or advice from counsel.
And lastly on this, did you understand that by 2006 the law required an expert report to contain a statement to the effect that the expert had complied with their duties to the court to provide independent assistance by way of objective and unbiased opinion in relation to the matters within their expertise, and an acknowledgement that the expert would inform the parties and, where appropriate, the court in the event that his or her opinion changed on any material issue?
In general terms, yes, but then, as I said before, instructing an expert, I would have got to know it in detail, and certainly I would have got advice and opinion as to what needs to go into the expert's report, and also as and when the expert need to be told about. When the expert is instructed, I would have included that in his instructions.
Would you have understood at this time that the requirements that I've just listed went to the substance of the expert's opinion and weren't merely box-ticking exercises that had to be complied with on the pieces of paper written by the expert? These went to whether the expert understood their duties and had approached their task compliant with their duties, and therefore this was a question of admissibility.
I think the answer would be the same as before, because it's not something I would do on a daily basis is something I have not done within the prosecution, what was prosecution for the post office.
And before embarking on the detailed evidence, can we agree on the following? Firstly, in the case of Seema Misra, no witness statement relied upon by the post office from Mr. Jenkins included any of the necessary inclusions required by the common law and the criminal procedure rules that I've just listed.
No, because he didn't come in as an expert in the sense of an expert. He was an expert who was experienced in the system in itself, because it's such a specialist system, and he assisting the prosecution, the defense, and the court into understanding how the system worked, or the operation of the system. I think that's why and how he came into advising. He came in as somebody who knew the system well.
So I think you'd agree that none of the witness statements supplied by
because he didn't.
Mr. Jenkins and relied upon by the post office in the case against Mrs. Misra included any of the necessary elements that I have just listed.
Yeah, purely because he was instructed as an expert.
I'm sorry?
He was not instructed as an expert.
I think as a matter of generality, before we come to the detail, you would therefore agree that you did not provide Mr. Jenkins with any instructions as to the duties of an expert.
No.
You did not provide Mr. Jenkins with any instructions as to the need to document, for example, the work carried out by him and by others which formed any part of the evidence that he was to give.
No, purely because he came in as a witness of fact. He was put forward or recommended by the Fujitsu as the best person who can answer or advise the prosecution, and in turn the defence. And I think all he did was to the questions posed by the defence expert to assist him to understand the system.
I think it follows that you did not provide Mr. Jenkins with any sort of document or schedule upon which he should record, for example, the material that he had considered in order to form his expert view.
I don't know what material I'm supposed to provide. It's like the way the whole he came into being was purely whatever information we had from the defence expert, and he was basically forwarding it on to him to respond to it like any other witness. I didn't take any witness statement from him, and I don't think I've actually physically met him until from the documents and the inquiry has provided me with. I think the first time was probably in a conference around about October, and I think 2 or 3 weeks prior to the actual trial. The normal practice of the post office was not the solicitor to take a witness statement, but to the investigation officer to do so. And that's how it worked out. Certainly the defence solicitors would send their inquiries, and I think maybe once they've put forward the challenge to the Horizon system, they instructed their expert. They in turn put forward these reports plus further inquiry, further inquiries. That went to the investigation officer. He in turn that this information needed to be dealt with by Fujitsu, and I think there was in place some sort of procedure, system, or process in place that needed to be followed. And I think because of the time constraints, or we needed to respond within a certain period of time, that's when I got in touch with the Prosecution Support Office, Fujitsu Prosecution Support Office, and they said, no, you've got to follow certain procedures, which would be time consuming. And just to escalate the matters, I was given a phone number for the head of legal at Fujitsu, who I contacted, and he recommended Mr. Jenkins. That's how he came into being.
Mr. Singh, can I cut through this? I'm just asking you at the moment whether you provided instructions, reminders to Mr. Jenkins of duties that I've outlined, instructions as to the need to document work carried out by him or by others that was going to form a part of his evidence, and with a schedule or work record that detailed the material that he had considered as part of his work. And I think your answer is no. Because I didn't think he was an expert.
No. Well, I don't know, but I think you followed it up, and you presumably wanted me to elaborate. But yes, no, that's right. You're right.
And I think it follows that there's no documentary.
No, because we didn't have any documents at that time. What documents could we have provided? So I didn't have any documents.
I think you're misunderstanding me. I'm asking whether you approached Mr. Jenkins on the basis that he was an expert, and then said to him, look, Mr. Jenkins, as you're going to be giving expert evidence, it's necessary for you to record in order that we, the prosecution, can disclose the work that you carry out in order to form your expert view, including a record of who you spoke to and communications that you received from others, insofar as they end up being part of your report.
At that stage, no. Well, at that stage, he wasn't considered as an expert. He was just more or less responding to the expert's report or their inquiries or their questions, if you like, because he was he was put forward as the person who could deal with them. So he was he was like any other witness we would have in court to give evidence.
And do you have conferences with any other witness? Do you sit down with witnesses of fact and discuss their evidence with them? Before a couple of weeks before trial, in a barrister's chambers?
Well, we didn't have any trials. I mean, certainly I...
Sorry? No, I'm talking about Seaman Misery. You've told us that you attended a conference with counsel, Warwick Tatford, in October 2010, and Mr. Jenkins was present, which you mentioned earlier.
Yes.
Was it usual for you to sit down with witnesses of fact and chat through their evidence with them?
I think it depended very much on the case.
So you would sometimes chat through a witness's evidence with them in a prosecution?
I think with some of the time, some of the areas certainly we did, in the sense that try to understand the actual system or the technical aspect of it. I think I don't know. Maybe it's I can't. I mean, I think I'm sure we have.
Presumably, you want to keep a pretty careful record if you were chatting through the evidence of a witness of fact a couple of weeks before trial, wouldn't you?
No, well, certainly, but I mean, certainly the investigation officers. To be honest, I can't recall exactly whether where we were, how we dealt with it now. But certainly, I always had my notepad with me.
Whereas the fact that you met Mr. Jenkins in consultation with counsel
I don't-
couple of
Well, I
weeks.
haven't taken any papers with me from the post office when I left. Everything's there.
No, hold on, I haven't asked the question yet.
Well, that's where you're coming. Well, okay, ask the question.
Just wait and see.
Okay, all right. Yeah.
Is the fact that you were attending a consultation or conference with counsel with Mr. Jenkins a couple of weeks before trial an indication that, in fact, you treated him as an expert witness? Because that's what one might do with an expert witness, rather than a witness of fact. Pretty unusual to sit down with prosecution counsel and chat through a witness of facts evidence, isn't it?
I can't really tell you how these came about. I think certainly counsel asked for a conference. And I think originally I didn't, I mean, it was such a long time ago, I didn't actually put it in my witness statement. And I think you provided further papers. And I think Mr. Jenkins said it was nice to put, nice to meet you and all the rest of it. Then I started remembering there was a conference. As to how that came about or what the circumstances were, I couldn't tell you. But certainly, we got a very experienced counsel who's been dealing with not just the post office cases, but wide experience of the prosecution for the CPS. He would have been well aware, and he would have made me well aware as to what I needed to do, as well as his duties. And I think he must have either the specifics of him being, his duties, my duties. We would have done that. But
I think it's right that there's no documentary record to which you can point that confirms that Mr. Jenkins understood, to your understanding, any relevant expert duties that he owed to the court. Is that right?
Well, it follows because, as I say, he was never instructed as an agent from the outset, as an expert. Sorry, I'm trying to think at the same time as because his speciality his expertise was very, very specific, very specialist, and that was the special tailor-made system for the post office, which his employer provided for the post office. So he wasn't. I think that's where we were. That's where we were confused.
What were you confused about?
Confused as to whether he came as an expert or as a fact, because he was basically, literally assisting the defence expert, because the defence expert was not an expert on the Horizon system, if I can put it that way.
Did you feel confused at the time?
I don't know. I mean, I wasn't confused in the sense I think you mean. Certainly, I'm not, like I said to you, in this particular circumstances or in this particular incident, I've never instructed an expert for the post office in these incidents. So I was new to it in that sense, because it wasn't second nature. If you've been dealing with something, on a regular basis, you would have everything in place. I would have had to basically start from scratch and work out the particular terms or the law, so to speak, as to my duty of the expert, because I don't think anybody within the criminal law team had he actually instructed an expert in that sense.
Can we look at your witness statement, please, at page 24? Thank you. And paragraph 69, please. If we scroll down, thank you. You say in the Misra case, the defence expert raised questions. I contacted the investigation and security team to ask whether they could answer these questions. I was told the request needed to be made in writing and it could take weeks for a response. I was worried that the normal systems and procedures for obtaining information from Fujitsu would be too slow. So I also contacted David Jones, head of legal at Fujitsu, to escalate the request, and so it would be dealt with as quickly as possible to comply with the court order. Subsequently, Gareth Jenkins was put forward to deal with the defence requests as someone who was in a position to deal with the issues raised by the defence expert. But I understand that his role was initially limited to that of a lay witness who knew the Horizon system well. As far as I can recall, the Post Office did not seek to rely on him as an expert witness, or at least initially. Subsequently, due to his expertise and qualifications, the court considered him an expert. Do you see that?
Yes.
So you're saying that you and others within the Post Office did not seek to rely on him as an expert witness, at least initially, but the court did.
Well, I think isn't that what?
Is that correct? That's what you're saying?
Yeah, isn't that
right?
what I've been saying all along to you? Any case. I mean, I don't think that is any different to what I've been just telling you.
And then if we can turn, please, to page 67. Paragraph 198, you say, initially, I did not consider Mr. Jenkins to be acting as an expert, but to be brought in as a lay witness with technical knowledge who could respond to matters raised by the defence expert. And then at the end, you say, however, this was an unusual case in that he was not regarded by the prosecution as an expert witness, but from recollection, went on to be treated as an expert by the court. In both of those paragraphs, you say that initially you did not treat him as an expert witness. Agreed?
Yes.
And in both of those paragraphs, you say that he, Mr. Jenkins, was treated by the court as an expert. Agreed?
Well, that's what I say.
Yes.
Yes.
And so, if you initially did not consider him to be acting as an expert, it follows, doesn't it, that there came a stage when you did consider him to be an expert. Agreed?
Not by. I don't. It's difficult because I think it's very easy to play with words, but in the practice.
Is that what you think I'm doing?
Well, no, I'm not.
I'm just reading out parts of your witness statement.
Maybe let me think then. Let me think quietly to myself. I was thinking loud. Maybe it's not the place to think loud. Let me put it differently to you then.
Just so you can refocus on the question.
Yes.
In 2 paragraphs in your witness statement,
yes,
you said initially, I did not consider him to be acting as an expert, ...
Yeah.
And my question is, does it follow that later, i.e. after the initial bit had finished, you did consider him to be an expert?
Only as an expert in the Horizon system, because we did not have anybody else to who had that specialist experience into the operation of it, the workings of it, and also even to analyze the transaction logs. And I think overall, in the scheme of things, in the case itself, he, and in turn, because of his expertise and knowledge, he was able to bring the defense expert to a level where he could actually understand the system.
Mr. Singh, in these 2 paragraphs, you're dealing with Mr. Jenkins' status.
Yes.
As to whether he was a lay witness or an expert witness. And in both paragraphs, you say initially you did not consider him to be acting as an expert witness.
Well, I think throughout...
But then, and I'm asking you, after that initial period had passed, did you treat him as an expert witness?
Okay. Can I share something with you? There would... the way this should have come about, or the way I visualized it, was that there would come a stage where we would get an external expert, whereby Mr. Jenkins would be able to assist our expert, our independent expert. I think that's probably true meaning, where we should have done, but at the same time, I think I was relying very much on the expertise and the knowledge and experience of our counsel. And that didn't come together. But initially, I think it would have been easy. I think maybe the way it should have been done would have been maybe we would have got another professor in. I don't know, but certainly here he did, in the true meaning of the word, he didn't come in as an expert. Maybe here it was very difficult to put it into words what I was trying to say, but he was treated as a witness of fact all the way through, up to including the trial, but maybe it should have been done differently. We should have got another professor in from the outset as an independent expert, but then who would have instructed him? Who would understand the system? It was that sort of real world problem.
Can we go back to page 24, please? Paragraph 69 at the bottom, last sentence. Subsequently, due to his expertise and qualifications, the court considered him an expert. Did the Post Office argue against the court's treatment of Mr. Jenkins as an expert?
Not to my knowledge. I wasn't in court. Certainly we were represented by a very experienced, knowledgeable counsel, and certainly he was instructed by the investigation officers was there, and I think one of our legal executives was there. I didn't get anything to anything like that. We said no, he's an expert. He's only an expert of fact.
So did the Post Office acquiesce in the court's treatment of him as an expert?
I don't know. I mean, I can't answer that. I mean,
when did the court subsequently consider him an expert?
Well, that was well, maybe it was wrong. I mean, doing this statement after a long period after the conclusion or the case has been concluded, it was a difficult one. I would have.
From when? What moment did the court treat him as an expert?
I don't know. I can't answer that.
Was Mr. Jenkins made aware of the change in status that he had enjoyed?
How do you mean?
Well, one moment he's a witness of fact in the person who's calling him as a witness, and then the court is treating him as an expert.
Well,
was he informed of his change of status?
He basically was treated as if somebody who knew the system well, because that's more or less what the court issue in the case was. And I think as you would be aware, I think the judge actually said to the defence expert and Mr. Jenkins to have as much time as possible with view to narrowing the issues to a point where there was actually a joint report which both these gentlemen agreed to.
And is that normal in your experience for the court to order two parties to meet, one of whom is an expert and the other who is a lay witness of fact, and to produce a statement of agreement and disagreement or a joint report?
Well, I've just said, I think we've been, for the last few minutes, I told you this is the first experience in the post office cases I've ever had. And I think I was very much relying on, our barrister basically saying, no, we can't use him. I mean, if he said to me right from the outset, Jarnail, we can't use him, then I would have stopped at that moment and see if we can try to find an expert outside, who was basically a professional expert, who gave evidence in court. But this was the only person that we were who was put forward, who knew the system very well, because this was a very, very specialist system. Only person who could actually not only assist the court, but actually went on to assist the defence expert.
In this paragraph, you refer to the normal systems and procedures for obtaining information from Fujitsu. What were the normal systems and procedures for obtaining information from Fujitsu?
I think I may be the wrong person to ask. I don't know to that, because wasn't privy to the contract or even the relationships. I didn't know people like Penny Thomas existed, the prosecution support office, who was basically...
You say here that you were worried that the normal systems and procedures would be too slow. You must have understood what they were.
What they were was when the investigation officer says, Jarnail, this can't be done, we've got to do this, we've got to do that. And that's when I got hold of Penny Thomas. And then I think that it came a time when she actually, sent me some email as to what the post office needed to do. And I think that's what we were discussing yesterday, wasn't it, when we were trying to get information from them. But like anything in life, they probably have got set procedures and systems in place, because I've never used them. It wasn't something that I was aware of intimately. I knew probably there would be, because there's a contractual commercial relationship between two parties, the Fujitsu and the post office. But as a legal, the prosecution solicitor in-house, something that I didn't use, I wouldn't be aware of in detail. I mean, I would know in general terms, because there would be some relationship, there would be something in writing, some contract or agreement. But I can't tell you now as to what they were. And even at that stage, I wasn't aware of it. All I was trying to do, from a practical point of view, from an empirical point of view, from the real world point of view, was trying to get this thing moving, because it's in court, and the judge had given directions, a timetable as to certain things needed to be done.
By the experts?
Yes, yeah.
So was it from that moment, from when the judge gave directions as to the service of expert reports and the meeting of experts, that you treated Mr. Jenkins as an expert?
Well, we couldn't find any experts from the outer world who knew the system. I did look.
No, my question, and I would really appreciate it if I'd appreciate it if you'd focus on my question rather than talking about other stuff.
Okay, fine. Okay.
Was it from the moment that the judge directed a timetable for the service of expert reports, and that the expert should meet and produce a statement of areas of agreement and disagreement, that you treated Mr. Jenkins as an expert?
No.
So despite the court treating him as an expert,
no,
you did not?
At that time, I'm talking about the... no, Mr... I'm talking... maybe at cross purposes. The time and the dates I'm talking about, Mr. Jenkins didn't exist. I didn't know anything about... I didn't know Mr. Jenkins.
So, okay, let's talk about the thing I'm talking about.
Okay.
When the court directed a timetable for the production of expert reports and directed that the expert should meet to produce statements of agreement and disagreement, from that moment on, did you treat Mr. Jenkins as an expert?
what date are we talking about? When are you? Because there's a date where they.
Autumn 2009.
I think that they wanted the experts, but we didn't have an expert at that time.
No. So when the court issued, we're going to come to them later. I'm just asking you on this issue at the moment. We're going to come and look at all of these documents in a moment.
No.
When in autumn 2009, the court issued directions that mentioned experts on each side, after that point, did you treat Mr. Jenkins as an expert?
No, because
Why not?
Mr. Jenkins wasn't there. Mr. Jenkins only came back around about February time.
Okay. So, did you know that Mr. Jenkins, as an employee of Fujitsu and somebody who worked day to day on Horizon, was a person where the prosecution, perhaps more than in other circumstances, needed to ensure that he understood his duties to the court?
Obviously, I knew he was an employee because he was recommended by head of legal for Fujitsu by his employer.
What about the second bit of the question then?
What's that?
Did you know that it was all the more important? He wasn't somebody that enjoyed functional independence. He wasn't independent.
But
That it was all the more important that you should ensure that he understood his duties to the court.
well, you're posing this question about 10, 15, 20 years after. That the focus there.
13, I think.
Well, 13 then. At that moment, I think my primary concern was to find somebody who knew this very specialist system, who knew the system. And as when the directions were given around about December, I don't know whether December or I don't know what the actual dates were, but year 2009, say. Obviously, my concern, or the post office concern, should have been, because I did sort of generally let it be known that this is where we are. We need to get an expert to explain the system. And I think the head of legal, Rob Wilson, said, well, we never had anybody. And I think a few others, Juliet McFarland, who was basically a head or leading the sub-postmasters cases, she couldn't come up with a name. I looked in the Law Society Gazette for an expert, and I think I went further afield. I think I spoke to the university, and they didn't know the system well, and I think that's where David Jones' recommendation of Mr. Jenkins came into being. And he came in as somebody who knew the system well. There was obviously, he's employee of the employer. Yes, of course. I mean, that follows then, doesn't it? Well, it doesn't follow, but obviously, yes, I would have been aware of that. But that wasn't the prime consideration. First consideration was like any person who could assist the prosecution and the court. And then I think was to understand the system at that stage, and maybe at that stage we should have brought in somebody from externally who was an independent, bit like the defence expert, to take it all the way to the court as an independent, and that's when the duties under the common law and under the statute would have come into play. That's when we would have formulated it in a sort of, if he was a professional expert.
Mr. Singh, I'm sorry to interrupt you, but you just told me in one part of a very long answer that you were looking for an expert to deal with the issues arising from Horizon. You told me that you were unable to find such a person, and therefore Mr. Jenkins was introduced to you. What better evidence do I need for the fact that Mr. Jenkins was an expert than that which you've just said?
Well, sir, I understand that, but then
Well, then, if you understand it, will you concentrate on Mr. Beer's questions and answer them a bit more succinctly, please?
So it's very difficult to work something in my head as quickly as Mr. Beer can, because I'm up at an age, and I've
Well,
been
then
out of practice such a long time to put it
Take
together.
a breath before you answer. Think about your answer.
I will,
and
sir.
then
I will.
answer.
Is there any way I can have pen and paper and I can sort of do that? Because I can't.
Of course.
Can't,
Let him have some. Let's have a morning break and let Mr. Singh have some paper and pen to prepare himself.
That's
to
very
answer your
kind, sir.
question.
That's great. I'm very grateful. Thank you.
Sir, can we say 25 past, please?
Okay.
Yeah.
Thank you very much. Good morning, sir. Can you continue to see and hear us?
Yes, thank you. Yes.
I'm pleased to say Mr. Singh has now got both a pen and
So thank you very much.
paper.
Thank you.
Can we turn, please, to your witness statement at page 25, please? Paragraph 70,
70.
fourth line. You're dealing here with the conference that you referred to earlier in October 2010. And you say in the fourth line, as far as I can recall, and then you corrected this, to I had more involvement with Mr. Jenkins. I cannot recall any discussions where he was informed of his duties to the court, although I would have assumed counsel would have informed him of the same. If you were not treating Mr. Jenkins as an expert witness, why did he need to be informed of duties that he owed to the court?
Well, it's such a long time ago. There's been a lot of papers which the inquiry has provided to me. I honestly can't say that, but certainly as far as I was concerned, he was a normal witness who knew this particular system, which the court needed assistance with, and so did the prosecution and the defence. As to again, it's an assumption. I'm an assumption from reading the papers. I don't know the ins and outs. Don't forget, I've been out. I've not been out. I've been not doing prosecutions a long period of time. At that time, I would have known because I attended a lot of courses. I had a lot of the papers with me, but at that particular moment in time. When I'm making this witness statement is relying on a lot of information, and I'm trying to summarise or be as brief as possible. So I can't honestly answer you why I said what I did.
So your position, that can come down, thank you, is that you at no stage treated Mr. Jenkins as an expert witness, but the court did. Correct?
He was somebody who was there to help and assist, like any normal witness would do.
Can we look, please, at poll 302-0489? Thank you. If we scroll to the middle email, thank you. A bit further down. Oh, sorry, a bit further up. That's it, thank you. Dealing with a different case here in 2012, September 2012, do you see? And you're engaged in a discussion about the choice of expert for it with Mr. Flemington, Mr. Bolk, Martin Smith and Harry Bower, yes? Can you see that?
Yes, I think CC'd in by Andy Cash, I think it was.
Yes, the email is directly to Andy Cash.
Yeah, it's a discussion with him.
Yeah, so this is about a different case, it's 2 years on.
Yeah.
And you say in your email, thinking about choice of expert in this case, that's the Wiley case, okay? I have in the past instructed Gareth Jenkins of Fujitsu in the case of Misra. which incidentally was the only challenge on Horizon. He provided expertise in dealing with defence's boundless inquiry into the whole system. Perhaps we need to reconsider whether to instruct him, as he may be viewed too close to the system, but instruct somebody entirely independent. Your thoughts, please. You say there, I have in the past instructed Gareth Jenkins of Fujitsu in the Misra case. That's true, isn't it? You instructed Gareth Jenkins in the Misra case.
Well,
Is that true?
he was put forward. I mean, I didn't. Well, what instructions have I given him? That's the whole point. He gave instructions to our investigation officer. I didn't take any. I never instructed him as such.
Why did you say, if you had never instructed him,
Well,
I have instructed him?
It's terminology, it's wording. Maybe it's clumsy wording, but I mean, when you're, this is a while back. This is going back. You're writing something out under pressure. Now, looking at it now, it was clumsy. It shouldn't have been. In the past, we have used as a witness or something like that. Maybe something to word instructed in that sense.
You agree that the language that you used is suggestive of you viewing Mr. Jenkins as an expert witness?
It's clumsy.
No, just focus on the question. You agree that the language that you used in this email is suggestive of you viewing Mr. Jenkins as an expert witness?
It's
Yes?
the meaning isn't in that sense that he's instructed as an expert.
Does a solicitor ever instruct a witness of fact?
No, but I mean,
Does a solicitor instruct an expert?
yes.
You said you instructed Mr. Jenkins. Agreed?
I think maybe that's the wrong word.
Why did you use it?
Well, this is, 12th of September 12 at 15:36, and now we are 23. So I don't know. I mean, I can't put my hand on the heart and tell you one way or the other, but it's clumsy. It should.
Let's look at poll 303-1352. This is an email from you to Hugh Flemington and others, dated the 1st of July 2013, with the subject of discuss of defect in Horizon in court, Seema Misra and Lee Castleton. Yes?
Yes. Sorry, yes.
And then if we scroll down, please. Paragraph 3, if that can be highlighted. You say in your email, we instructed our own expert, Gareth Jenkins from Fujitsu. If you did not instruct Mr. Jenkins as an expert, why did you say we instructed Mr. Jenkins as an expert?
Clumsy. It shouldn't have been. It's wrong. I can't explain to you. I mean, he's years on. He was, the best I can put it to, he was expert, or he knew the system for Fujitsu like no other person, and he was there to assist all parties, prosecution, defence, and the court.
Isn't the reality of the position that you either didn't understand what the duties were in relation to the treatment of a person as an expert witness, or you simply didn't care enough to see what those duties were and ensure that they were discharged, and that after the fact you've invented this idea that you were treating Mr. Jenkins as a witness of fact throughout and not an expert, to cover for the fact that you very well know that you complied with none of the duties that you owed to him?
None of what you said is true.
So why?
I don't agree with it.
Why have I been able to find two emails in which you have said, in black and white, that you instructed Mr. Jenkins as an expert, when you say that's exactly what you didn't do?
The reality is, I attended a lot of courses. At that particular...
That document can come down, by the way. So you were telling us about courses you attended.
Yep, I knew at that time what my responsibility and duties were. Mr. Jenkins, as I explained to you at that time, came in as somebody who knew the system very well, better than anybody else. And he could assist the prosecution, the defence, and the court. And that's what he did. And he came in as an expert in anything apart from being an expert in the system itself. And so...
that explains what you now say. I'm asking you to explain why in these emails that I've just looked at, you say, I instructed Gareth Jenkins and we instructed our own expert, Gareth Jenkins, when you say that's precisely what you didn't do. I don't say it's just clumsiness.
It's clumsiness, laziness, you name it, but it's he... I think
Why were you being lazy?
I think it's probably the day-to-day pressures. And I think the other thing is, like any good lawyer, is that you need to
use language precisely?
Well, maybe I should have been more precise and concise. It's, maybe I'm probably being more informal because it's internal. But certainly he was not. If the witness statement, that's what is what I've signed up to, and that's what I did. And I can't even say why you asking me that when I got that witness statement here, to that fact that he wasn't instructed as an expert from the beginning to the end, not by me, and that's the reason why a lot of the the statute, common law terms and conditions were not put in that way, because he didn't do any of that. All he did, he came and explained the Horizon system.
So you say that you've got a witness statement saying that he wasn't an expert. Is that your witness statement?
This is what I'm telling you. This is...
Well, just because you're saying it in a witness statement doesn't mean it's true, does it?
Why not? That's what I believe. That's what I signed up to.
Right. So because you... Okay, got it. So you're saying that because it's in the witness statement you're pointing to on the desk there, it can't be the case that you treated Mr. Jenkins as an expert?
No.
Aren't you just covering up the fact that you know that he was treated...
Why would I cover up? I mean, no.
Because you know that you complied with none of the duties that you owed as a prosecutor. So you've rewritten history. You've said, I didn't treat him as an expert at all. He was a witness of fact throughout, despite how you've described him in these two emails, and despite the fact you attended a conference with counsel with him and chatted through his evidence.
I don't know. I mean, I don't know where you get that we chatted through his evidence.
What did you do? Did you sit there in silence?
I have no recollection of what were... I mean, I don't know whether you... But there's a attendance note to that.
No, well, that's significant. We haven't had disclosed to us an attendance note of what happened at the October 2010 conference.
As I said to you, that when I left the post office, I didn't take any papers with me. So I can't tell you, I can't assist you any further.
Can we turn then to the unfolding correspondence over the Seema Misra case and Mr. Jenkins' involvement in it, and start with Fujitsu 0015 2843. This appears to be the first communications concerning what was eventually to be Mr. Jenkins' witness statements. And what I'm going to do is track through how they came to be provided. Okay? This is an email exchange, I think not involving you, from Mr. Longman. he says, Jane, I attach a report from the defence expert where he's highlighted a number of problems with the Horizon system. Warwick Tatford has asked that the problems with Horizon that he has raised in his report are replied to in a witness statement form. I presume that an employee of Fujitsu would have to produce the witness statement. In addition to this, the defence have requested the following information. Yes?
Yes.
Can you help why it was that it was the investigator rather than you who was seeking a response to the expert evidence?
I honestly don't know. I can't help you with that.
Was that usual that the investigator would commission evidence like this from Fujitsu rather than you doing it?
I don't know. I mean, I can't explain it. It's such a long time ago. I mean, I can't really. I've been out of this area of law. I can't really deal with too much detail you're looking into. I can't help you.
But would you agree that at the moment here, the communication from the investigator is not treating Mr. Jenkins' evidence as potentially expert evidence? It's asking for a reply to expert evidence in a witness statement.
Yes.
You're not copied into this, I think.
No.
Now, at the same time as this was going on, can we look, please, at poll 305 3723?
Oh, okay.
Can you see this is dated... sorry, if we scroll down, please. 11th of December 2009. Mark Dinsdale, can you remember who he was?
I don't know, one of the investigation officers, I think, but I
Okay.
don't know the direct instructions from him. I don't know.
He emails Mr. Wilson, Rob, I'm looking for a bit of guidance on this request from John Longman in respect of Seema Misra. That's the one we've just looked at.
Yes.
This is a huge piece of work that could potentially wrap up my team for weeks, and then only to be asked more questions of a similar nature. I've also concerns over the types of questions that are being asked and whether we can actually provide the information. We're a new team and we'll really appreciate your guidance on this, on how to move this one forwards. Are these questions that yourselves need to answer from a legal perspective? Clearly some of these questions are unspecified, are so unspecified that we could be dragging up Horizon reports for almost every branch over a 10-year period for every single week in question. I hope you can help and provide some guidance on this one. Thank you. And then if we scroll up, please. You send that on to Warwick Tatford. You reference the email. You say he raises a number of queries and wants solutions to the disclosure, which have, in my view, unreasonably and unnecessarily been raised by the defence, and you seek advice. And you say this may have a wider implication for the business and look forward to receiving his advice as soon as possible. Can you explain, in relation to this request, why you regarded the defence request as unreasonable and unnecessary?
I can't, because I don't know what information they're requiring.
If we scroll down, we can look at it. It's at the foot of the page. It starts with 1. Please find attached a statement from Eleanor Nixon. Please provide the following information. And then over the page. Would you read that slowly to yourself? And then scroll down. If you read 2 and 3 to yourself. And then scroll down. There's a reference to some other cases, including MacDonald and Hosey. And then over the page. Please provide details of post offices past and present that have experienced losses with the Horizon system, prosecutions past and present that have been brought for theft or false accounting as a result of alleged losses. Let's go back up to page 1. But why did you regard the defence requests as unreasonable and unnecessary?
I can't answer that. I don't know.
Okay.
Years on.
Can we see what Mr. Tatford said when he replied? Poll 304 4557. If we go to, this is Mr. Tatford's advice. Take it from me, it's dated the 5th of January 2010.
Yes.
And if we can go to paragraph 6 and 7, please, which I think is on page 2. He says, I would wish some further inquiries to be made from Fujitsu. Paragraph 23 of the Castleton judgment refers to the evidence of Anne Chambers. When she was cross-examined, over the page, please, she appears to have had knowledge of an error in Horizon that had occurred at Callender Square in Falkirk. I've seen some civil paperwork in relation to Alan Brown, but not concerning a Horizon error. I don't know if Anne Chambers still works for Fujitsu, but it should be relatively straightforward for Fujitsu to provide full information about what appears to have been a well-known problem at Callender Square. And then 7, I think our disclosure duty requires us to ask Fujitsu whether they're aware of any other Horizon error that has been found at any sub-post office. And he says, I anticipate there will be none, but it's important that the check is made. Before approaching Fujitsu, would you agree that as the prosecutor, the post office was under a duty to disclose any information which it, the post office, held about, firstly, the Callender Square bug, or secondly, awareness of any other Horizon errors that had been found at any sub-post office?
Certainly, if it undermines the prosecution case and it assists the defence, that's what the test is.
So what did you do then to obtain from the post office itself, before going to Fujitsu, documents falling within either of those categories?
I don't recall what I did or didn't do. I mean, it's years ago. I mean, I can't tell you chapter and verse what we did or didn't do. I can't answer that in, 10, 12 years on.
Did you ever consider that the post office itself owed disclosure duties of the kind that I've mentioned before turning to Fujitsu? Are you looking within itself at all departments or branches within the post office for information that tended to suggest that there were errors within Horizon capable of affecting the integrity of financial accounts?
Again, I can't answer that, but certainly it would have been highlighted to the team internally.
How would it have been highlighted to the team internally?
Certainly this advice would have gone to the head of criminal law team, and then I would have seek directions from me as to how do we go about doing it. But I mean, I can't.
I'm asking about a different thing at the moment. I'm asking about before you go to Fujitsu and asking them whether they have got information about Horizon integrity issues, to use a portmanteau phrase.
Yes.
Whether you went to anyone within the post office to see whether there was such information.
I don't know. I mean, I can't tell you what we did so many years ago, but certainly, certainly if we had the information, we would have considered it, and we would have dealt with it.
You see that the way that Mr. Tatford has expressed himself here, would you agree that he is asking that inquiries be made of Fujitsu, the corporation, on both fronts, not inquiries be made of Mr. Jenkins?
Yes, that's what he implied. Well, that's what he's saying, but that's what he's saying. But it doesn't mean say that we haven't carried out internal inquiries. But I can't tell you how we went about doing that. I don't know the answer to that question. I don't recall. I mean, as to how we went about doing it. But certainly, if we had the information, or we would have sought it, I suppose. But I can't answer that. I can't give you, So I don't recall now. So many years ago.
But on the separate issue of, let's put aside what documents the post office has got going to each of these 2 points, when we turn to a third party, Mr. Tatford is advising that the corporation be approached in relation to both issues, not that Mr. Jenkins be approached in relation to both issues.
Yes.
Agreed?
Yes.
Can we go on, please, to FUJ 0015 2887? We're now at the 27th of January 2010. And this is a communication from Mr. Longman to Fujitsu, Penny Thomas in Fujitsu. And can you see, he says, our defence barrister has asked for all of Gareth's replies in relation to the defence's second interim report to be produced as a witness statement. I would suggest that the question from the defence is reproduced and then Gareth's replies are recorded immediately after for clarity purposes. And then there's some timing issues. Again, why was Mr. Longman, rather than you, communicating with Fujitsu as to the evidence that needed to be sought?
That's the post office system. That's what we did. I mean, certainly in private practice, I took the solicitor or his assistant, if you like, or his personal representative, took the witness statements. But in post office, ever since I've been there, it was always the investigation officer who did that, and that. But in these circumstances, I don't know. That's what the process was.
And you're not even copied in on this, so this is going on without your knowledge. Is that right?
Isn't that? I can't. I don't. But I'm not copied into this particular one. I don't know whether he sent me anything else. I can't recall. I don't remember.
Let's go on to poll 305 3745. You can see that you're the author of this memo. It's addressed to Post Office Security with a copy to the investigator, Mr. Longman. And you say, I now enclose Counsel Warwick Tatford's advice and would be grateful if you would kindly please deal with the outstanding matters with regard to the disclosure which the defence are seeking, and should deal with it paragraph by paragraph, so it's probably easier to deal with. Yes?
Yes.
So essentially you're post-boxing on counsel's advice, saying, can you please, investigator, deal with it all?
I think that's that's how we. That's what the process was. We didn't was to actually send the advice to the investigation officer, not to. I mean, there's certain bits he obviously couldn't deal with, but which we would have dealt with, or somebody else he could who would have knowledge of. But that's the way the system of the process worked. I mean, I can't say any more than that. But I mean.
You remember Mr. Dinsdale had raised questions about the scope of the disclosure that the defence were seeking.
Yes.
And you had commented that it was unreasonable and unnecessary. And then Mr. Tatford had advised that these are the things that you need to do. Where you say in the last line, or the penultimate line, please advise Mark Dinsdale accordingly, were you telling Mr. Longman that he should feed back to Mark Dinsdale the response to his concerns of the parameters of the defence's disclosure requests? You weren't responding to Mr. Dinsdale yourself. This is what I think, this is what counsel thinks about the disclosure requests. It's going to tie up the department. It's going to grind work to a halt. You were saying, here's the advice. You, John Longman, tell Dinsdale that's the outcome.
I don't know. I mean, at that particular moment in time, I don't know where we were, what we were thinking, but it's presumably just a simple thing. Well, look, Mark, I've got counsel's advice. I'm dealing with it. Just to keep him informed. I mean, say, well, look, it's been dealt with, or it's in hand. I mean, I can't tell you precisely. I don't know the answer to that, as to what you're asking me about that. But all I'm saying is that they presumably both investigation officers to say, look, Mark, it's been dealt with, or I'm dealing with it.
So you faithfully sent on counsel's advice to Mr. Longman, yes? Agreed?
That's what. Yes, I mean, that's what I'm doing.
And you'll remember that Mr. Tatford had advised our disclosure duties require us to ask Fujitsu whether they're aware of any other horizon error that has been found at any sub-post office. Remember?
Yes.
If we just go back, please, to FUJ 0015 2887. And scroll down. This email from Mr. Longman to Penny Thomas in Fujitsu doesn't include that question, does it?
What question? Sorry.
Let's try and look at two documents on the screen at the same time to try and help you. Can we have on the left-hand side, poll 304 4557? And look at the second page of the left-hand document. Sorry, third page. All right, can you read paragraph 7? I think our disclosure duty requires us to ask Fujitsu whether they're aware of any other Horizon error that has been found at any sub-post office. Yes?
Yes.
And then look at the email on the right-hand side. What was in fact communicated to Fujitsu?
Yes.
Doesn't include that, does it?
I don't, what's he attaching? Is he attached below? I don't know. To be produced at the various. Is that the?
That's Professor McLachen's second
Oh, sorry.
interim report.
Yeah, sorry. It's not there. Yeah, I confirm. Yeah, I agree.
That's a significant omission, isn't it?
Yes. Yeah.
Prosecution counsel has said that the prosecutor's disclosure duties require us to ask Fujitsu whether they're aware of any other Horizon error at any sub-post office. And that question's not asked there, is it?
It doesn't appear to be, no.
All of this was going on without your knowledge, wasn't it? You weren't involved in it, were you?
I'm not copied in.
Why was it going on without your knowledge?
I don't honestly. I can't answer that. I don't know why, but that's. I can't answer that. I don't know. I don't recall.
Can we go to poll 304 4553, please? This is your letter. If we just go to the last page. See, you signed it off. Go to the first page, please. Of the 27th of January to the defence solicitor Izzy Hogg. Counsel's drafting his response to the Section 8 disclosure application, turning to the defence, the request for further disclosure. Scroll down, please. You deal with contract, training. Over the page, please. You respond to investigations, and scroll down, please. And scroll down again. Under Horizon System, you say, we can understand why you would want to see specific areas of the Horizon data. Your expert will want to check his theories against the relevant data. Your client will also presumably be able to direct you through specific types of transactions where she feels errors may have occurred. We do not understand how your expert will be assisted by being presented with a mountain of data covering 5 years. You say that Horizon has undergone stringent testing before it was installed. And then over the page, please. And then under 19, you say in the second part of it, the investigation officer, John Longman, said he's prepared to meet the defence expert with one or more representatives from Fujitsu to discuss technical issues and reach as much agreement as possible. This will obviously avoid much wasted time. Could you consider the point and revert back to you? So you were making an offer that Mr. Longman would meet the defence expert with some representatives of Fujitsu to discuss technical issues, correct?
Well, that's my instructions. It's not something I arranged. It was something I was instructed to put forward.
Who instructed? Would that be the investigator?
That's what it says. I mean, I wouldn't be doing it on my own back. It would be instructions come from the investigation security team by John Langman as to who authorised it. Presumably he's spoken to Fujitsu and who are happy to do it. So
Would your understanding, and after all this is your letter, be that such Fujitsu representatives who attended such a meeting would be attending the meeting in the capacity as operators of the system with some knowledge of it, or attending such a meeting as instructed expert witnesses?
I don't know what you're asking me. I mean, if you break it down a little bit, because this is years on. I'm trying to assist the inquiry as much as I can. I don't, know the case now as much detail I did at that particular moment in time. So if you break it up, then certainly I can help. Otherwise, I can't recall as to precisely the nature of that communication but I can tell you it would be something, like any client instructing a solicitor to do, and that's why I'm putting it forward to the defence solicitor.
So can I take from that you would just relay of instructions, you didn't apply your mind to what's happening here? A defence expert coming into the premises of the operators of our system and meeting them. What's really going on here? In what capacity are these representatives from Fujitsu meeting this defence expert? You would have just forwarded essentially what your instructions were.
No, I don't know what I did at that particular moment in time. It's such a long time ago, but it certainly would have been discussed and considered. And I certainly, Fujitsu wouldn't allow any person just to enter. There would be certain conditions as to it, and I think it may just be. Maybe I shouldn't really speculate. I honestly cannot assist and help the inquiry with that, but certainly it would have been considered. It wouldn't be post and paste job saying, well, look, this is you're welcome to do this. It's not as simple as that.
Okay, we'll move on. 1st of February, please. FUJ 0015 2902. And if we scroll down, please. Sorry, it's over the page. Thank you. John Longman to Penny Thomas. At a pre-court hearing today, the judge ordered that all the defence requests for further information be answered by 4 p.m. on Monday, the 8th of February. Our solicitor in the case has asked that Gareth's statement is completed by Wednesday of this week so that he and our barrister can examine the statement. Just stopping there, the solicitor in the case, that would be you, would it?
Yeah.
Gareth's statement needs to cover the following 4 points. One, our defence barristers asked for all of Gareth's replies in relation to the defence's second interim report to be produced in a witness statement. That's essentially repeating the email that we saw earlier. 2, my barrister telephoned me yesterday evening and requested I find out any information that Fujitsu may hold in relation to an office called Calendar Square in Falkirk. Apparently Anne Chambers, a systems specialist employed by Fujitsu, was cross-examined, etc., etc. Our barrister would like Gareth to deal with this matter and expand upon whatever issue Anne Chambers raised at court. So remember, that reflects paragraph 6 of Mr. Tapford's advice. Agreed?
Well, yes, yeah.
Okay. And then third, when Gareth completes his statement, could he also mention whether there are any known problems with the Horizon system that Fujitsu are aware of? If none, could this be clarified in the statement? That's different from what Mr. Tapford had advised, isn't it?
Yes, it is. Of course it is.
What do you notice about the difference?
In hindsight, yes, but at that moment I don't know what it was, but certainly, if you, I can't recall word for word what that was, but if you bring the other one up, and then you can see there is a difference, there is a marked difference.
Let's do the right-hand side thing again. Left-hand side, poll 304 4557. Page 3. Paragraph 7. Paragraph 7.
Horizon errors.
So compare paragraph 7, left-hand side, to paragraph 3.
There appears to be something missing, isn't there? I don't know whether. System what visit you are aware of. Oh, yes. Error. Yeah, that horizon error should be in there, yes.
Sorry, I can't
Yes.
hear you.
Yeah, there is obviously a difference. Yeah, there should.
What differences do you notice?
Well, the horizon errors, it doesn't say anything about that, does it? Horizon system that visit you are aware of. It says it doesn't mention errors.
Well, the first thing is that the advice from Mr. Tapford is that it should be a request made to Fujitsu. Yes?
Yes.
That's been translated into a request for a mention by an individual, namely Gareth Jenkins. They're different things, aren't they?
Now looking at it with the time, careful focus, yes.
It's a watering down, isn't it?
It shouldn't be, but it is what it is. I to be honest, now that we got the time and being able to focus on it, and you've certainly highlighted it, yes. But I can't recall what we did at that particular moment, or or the way it came back, or whether we did anything after that. I don't know, but I can't explain that to you, because I don't remember. I don't recall.
Did you have any input into how the question was reformulated? That it was turned from a request to ask Fujitsu, the corporation, of whether it was aware of any other horizon error in any sub-post office, to a request to an individual to mention if there are any known problems that Fujitsu are aware of?
I don't recall.
You can't recall whether you had any input into the reformulation of the question?
That bit, I obviously, that is, John Longman's email, but certainly I don't recall as to what transpired after that.
Do you agree that the request that's now directed to Mr. Jenkins has conflated the separate issues of a response to the defence expert report and the Post Office's own response to the defence's request for disclosure, in respect of which Mr. Tapford had advised?
So long, I can't explain, because I haven't got the details, or 10 years on, 12 years on, it's different. But I mean, I can't answer that. I don't know. To answer to your question, I don't recall, and I can't really answer that.
Were you aware at the time of a prosecutor's duties in respect of third-party disclosure or obtaining material from a third party?
But you mean internally or generally? How do you mean?
I'm afraid I can't express it any better than that, even if I rearrange the words in the sentence.
I don't know at the moment. I can't tell you what the duties were. Maybe at that time, certainly I would have been, But I mean, to look at it in that much depth and detail now, I don't know. I mean, the answer to that, I don't recall where we were.
Would you agree that when a prosecutor is approaching a third party in order to assist the prosecutor, in discharging its disclosure obligations, it should explain to the third party that it is doing so and the importance of the third party conducting inquiries itself that are both recorded and auditable, in order that the prosecutor can then explain to the court what it has and hasn't done to discharge its disclosure obligations?
I can't recall as to whatever you're asking me. Purely at that time, I would have assumed so, because I've been up to date with a lot of the legislation or a lot of the requirements, but I can't answer to now, moving on, because all the information you provided, and now is completely different in the sense that I had the chance to look at it, but even then my head is not with the prosecution hat on it or head on it, purely trying to assist the best I can the inquiry.
Would you agree that a prosecutor seeking disclosure from a third party should explain to the third party the nature of the duties that both the prosecutor, and the third party were under? Give some guidance to it.
I don't know. I don't recall as to what the relationship is here within Fujitsu in partnership. I mean, I say I don't got involved in the contractual or commercial side of the business as to how we went about getting information on Fujitsu, and but certainly I years on now, I can't tell you what I knew then or I didn't know at that particular moment in time, so I can't assist you any more than what I've just said.
Do you agree that this watering down that we see here essentially means that what was advice from counsel to ask a corporation whether it was aware of any other Horizon issue at any other sub-post office has been turned into a rather casual request to an individual that they might mention anything in their witness statement of problems of which Fujitsu was aware?
Well, that what it appears to be, but as to what the reality was at that particular moment years ago, I don't know. But certainly from the information you've given me, I can't really give you much detailed.
In any event, this didn't, on the face of it, amount to an instruction to Gareth Jenkins as an expert witness in the case, did it?
Well, as you said, that email is not copied to me, so I'm not aware as to what whether Gareth. Well, he's obviously saying Gareth Jenkins should deal with it, but certainly I can't give you any more detail than the fact that I don't know.
I mean, taking a step back, would you agree overall that what we've seen so far is that the Post Office appears to be proceeding on the basis that it needs some information from Fujitsu in order to disclose its obligations as a prosecutor by way of disclosure, and that has been conflated with a request being made to Mr. Jenkins to provide a response to a defence expert report? That's what it looks like, doesn't it?
Well, it looks that way, but I can't say for sure as to. A lot of the time, as the information comes, and then you look at it, you review it, and then you flesh it out a little bit more. I mean, that's how some of the information is dealt with, but I can't really assist you or the inquiry any further than what's in front of you.
Can we move forward a few days to see when you become directly involved, to the 5th of February 2010, FUJ 00122713. And if we scroll down, please. can we see at the foot of the page your email to David Jones of the 5th of February at 12:34. And you say, "Dear Mr. Jones," if we carry on down the page, "I refer to our telephone conversations of 4th and 5th of February 2010 with regard to the obtaining of a witness statement of the defence challenging the reliability of Horizon. I understand that Mr. Jenkins has been identified as an experienced person to give this statement. I'd be grateful after your meeting this morning if you could confirm to me when Mr. Jenkins would be back to return to duty after his sick leave." There's a court order with a deadline of the 8th of February. By this time, had you seen the exchanges of the 1st and 2nd of February that we'd looked at earlier?
I don't know. I mean, I can't recall as to where we are.
So just scroll down a little bit further. A bit further, please. I think that's the end. So this doesn't appear to attach the chains that we've looked at earlier of the 1st and 2nd of February with communications from Mr. Longman into Penny Thomas. If we scroll back up to your email. It seems like you spoke with Mr. Jones on the 4th and 5th of February.
Yes.
Why had you become involved at this stage?
I don't know, to be honest with you. I don't recall as to. All I know that I've spoken to him, and I've asked for help, assistance with somebody who can help and assist with the prosecution.
Okay, if we scroll up, please.
That's about it. I mean, I don't know the ins and outs. Why?
Look at
why
Mr.
not?
Jones's reply.
Where are we?
Jarnail, thank you for your attached email, which I've now received. Looks like there's been some problem getting there. I met this morning with Gareth Jenkins, who came back into the office to meet with me. Gareth will help with this matter. His input will be coordinated by Penny, who's responsible for delivery to Post Office Limited of support in this security area. Attached is a first draft of a statement from Gareth. I'd like you to review it and indicate if it answers the question in detail you require. You'll see there are some areas where Fujitsu cannot deal with the defendant's expert's criticism, as they're about Post Office Limited procedures or requirements, and it seems evident that there will need to be a Post Office Limited internal expert who can work with Gareth to deal with these areas. One concern is that Post Office Limited have not apparently requested transaction data for West Byfleet for the period and transactions in question. This would normally be provided in previous cases and would include Fujitsu extracting log files from the system to enable us to provide details of transactions. Surprisingly, this has not been requested in this case. Perhaps you would consider the need for this. So Mr. Jones, the head of legal within Fujitsu, is saying, firstly, that Mr. Jenkins is going to help you. He's enclosing a copy of Mr. Jenkins' statement and asking you to look at it and see whether it answers the questions that you require in the right detail. There's going to be some things that he can't address, that there needs to be somebody from within the post office who can work with him to deal with those areas. But there's a concern that transaction data hasn't been requested, and that's surprising. Agreed?
Yes.
Mr. Singh?
Oh, sorry.
Yes.
Yeah, that's what
Okay.
it says.
Can we look, please, at poll 302 9369? And if we scroll down, please. Your email at 3:39 on the 5th of February. So I'm so sorry. Scroll down a bit further. Bit further. Thank you. Your email sent by your secretary at 2:53 to John Longman and to Warwick Tatford. Can you see that?
Yes.
Dear John and Warwick, here with statement from Gareth Jenkins, just off the press. Please let me have your comments on whether this is adequate for our purpose, or does it require any additions before being served on the defence? And if we just scroll down a bit further, keep going, we can see that you sent them as well, Mr. Longman and Mr. Tatford, Mr. Jones's email that we just looked at. Yes?
Sorry, say that again. Mr. Jones's email.
Yeah, you're forwarding to Mr. Tatford and Mr. Longman, Mr.
Oh,
Jones's email.
You're
giving them the first draft of the Gareth Jenkins statement.
Yes, yes.
And you're also giving them the text of Mr. Jones's statement raising the 4 issues that I mentioned. Yes?
Can you I don't know. I mean, I can't see. Yeah. Yep. Yes. Okay. Yeah. Yeah.
Okay, and then if we scroll up, please, and keep going. And if we look at, thank you, there, stop there. Mr. Longman's reply to you, same day at 3:39. He says, Jarnail, points 2 to 4 have not been answered, which I reproduce below. So he's cutting in the request that he, Mr. Longman, had made to Penny Thomas into an email to you and saying Mr. Jenkins hasn't answered them. And we can see them cut in, points 2, 3 and 4. Point 2 is the Calendar Square bug in Falkirk, yes?
Mm-hmm. Yes.
Point 3 is when Gareth completes his statement, could he also mention whether there are any known problems with the Horizon system that Fujitsu are aware of? If none, could this be clarified in the statement? So what Mr. Longman is telling you is that even the watered down request hasn't been addressed by Mr. Jenkins in his draft statement. Agreed?
Yes.
And then scroll on 4 isn't relevant for our purposes. Then if we scroll up, please. And again, then stop there. Mr. Tatford replies to you the next day. Mr. Longman sets out in his email below the extra matters I asked Mr. Jenkins to look at. The areas where Jenkins says for Poll to respond should be deleted. These will lead only to a flood of further disclosure requests. I'm afraid that Post Office will never respond. But let's see what you did with Mr. Longman's response, FUJ 0012 2729. So if you remember, you received the email at 3:39 from Mr. Longman. You say to Fujitsu, i.e. David Jones and Penny Thomas and Gareth Jenkins, dear David and Penny, on first glance, points 2 to 4 have not been answered, which I reproduce below. And then you cut in points 2, 3 and 4 from Mr. Longman's email. Do you see that?
Yes.
Please give this matter your urgent attention. Look forward to hearing from you. So you were going back to Fujitsu here and saying, we've asked you to mention whether there are any known problems with Horizon of which Fujitsu is aware, and you haven't answered the question. Was that a concern to you?
I don't recall. I mean, I can't give you any reply to that. I obviously considered it at that particular moment in time. As you know, straight away, I'm trying to put something together because there is time constraints on it. But with these inquiries, with the papers, I haven't had time to, reconsider to the detail you're asking me. So I'm sorry, I can't help you as to what you're asking me. Years on. And
What we've seen is a defence disclosure request being sent to prosecution counsel, him advising that a course of action needs to be taken, that course of action being watered down, that being sent to Fujitsu, and Fujitsu not addressing it, and then you writing to them and saying, you've not answered our questions. Agreed?
yes, yes.
Again, still at this point, and looking at the issue of your treatment of Mr. Jenkins, in the emails we've seen, you are not seemingly instructing Mr. Jenkins as an expert by reminding him or drawing to his attention of any of the matters that the criminal procedure rules or the common law required. Correct? That's just not a feature of these email exchanges, is it?
No, this is, agreed, yes.
Was it a significant concern to you that Mr. Jenkins had not addressed the issue of whether there were any known problems in the Horizon system?
Again, I can't answer that.
Well, it ought to have been, oughtn't it?
Sorry, I don't know.
You've got a defence expert saying there are problems with the Horizon system. You've asked somebody with expertise within Fujitsu whether there are known problems with the Horizon system, and he hasn't addressed it.
I can't answer that for...
Did that position ever change?
I don't know.
The question that Warwick Tapford had asked, whether in its original form or in its watered-down form, was that ever addressed squarely and head-on by either Fujitsu or Mr. Jenkins?
I can't recall. I can't give you yes or no answer.
Did you press that point? We need an answer, Fujitsu, to this fundamental question.
I don't know. I mean, I haven't read the paper. I mean, the only thing is that what you supplied me in the inquiry papers. Years on, I can't ask. I can't answer that in detail.
Would you have realised that if Fujitsu revealed known problems with the Horizon system, that would be significant information, not only for this prosecution, but for a number of prosecutions?
Of course, it would be.
It could bring an end to prosecution.
Yes, it should. But if there's a problem, an error, it should bring an end to prosecution. We shouldn't proceed with it.
And so it's a point that needs to be pressed hard, isn't it?
But as I say, I'm not the only lawyer dealing with these cases. Certainly, if I'm aware of something like that, then yes, it should be, yes.
Can we move on, please? Fujitsu 0012 2731. This is still later in the day, on the 5th, 4:28 p.m. You to Fujitsu again, Jones, Thomas and Jenkins. Dear David, please also get Gareth Jenkins to comment on the enclosed report. That's the third McLachlan report with a deadline of Monday the 8th of February. So I think you're sending this at 4:30 on a Friday, by the look of it.
I had no idea to what day it was.
Well, if Monday was the 8th,
Well, probably.
the 5th would have been the Friday, wouldn't it? Yes?
I don't know. But if you
Let's work out.
But no, you don't have to work it out. If you say so, it must be a Friday.
I don't want to get to the stage in asking you questions of how a calendar works, Mr. Singh.
No, if
you oughtn't to be so suspicious of me that if I tell you that Friday was
No,
the
I'm
5th.
not suspicious. I'm just saying, yeah, well, years on. I can't tell you the reason why, but certainly I'm trying to get the.
Do you agree that
the work
Friday was
done.
the 5th?
Yes, I agree.
Excellent.
Fine,
Because Saturday would have been the 6th, wouldn't it?
must be.
Yeah, and Sunday would have been the 7th?
Yes, agreed.
Good.
Presuming Monday was the.
So you were sending a request at 28 minutes past 4 on a Friday to Mr. Jenkins saying there's a court deadline for you to respond to this by 4 p.m. on the Monday, weren't you?
Well, that's what the court deadline. I'm stating a fact. I'm not I can only deal with what I have, and I certainly, my habit is that whatever matters in front of you, you deal with as much as you can. I mean, instead of going backwards and forwards. I mean, it's a Friday, but whatever it is, and I'm just highlighting this what we need to do. But whether
again,
he's able to do it or not is another thing, and then presumably would have to go back to the court and say, look, we couldn't do it, we've done all we can, please help.
Again, this doesn't incorporate even the most basic elements of an expert instruction, does it?
I don't know what more do you want me to say. Obviously it
An
doesn't.
answer to the question.
No, it doesn't.
Thank you. Can we move on, please, to FUJ 0012 2735? And if we look at 3 minutes to 5 on the Friday, Mr. Jones says, please see attached, and that's Mr. Jenkins' comment on the third interim technical report, and Gareth's comments on the need for an examination of the underlying log files and timing on this. And if we scroll down and see what Mr. Jenkins said, he says, David, I've provided inline comments to the documents as revisions. I'm happy for this to be passed to Post Office Limited if you feel it's appropriate. The simple answer is that without retrieving the logs, everyone is speculating. And as discussed this morning, nobody's bothered to ask us for any logs. At this stage, it's not at all clear what transactions are thought to be missing at what time or even in what time period. Analysing logs over a long period, and I think this is over 2 or 3 months, is very, very time consuming. This is not going to happen by Monday. And he asked for a copy of Mr. Dunk's witness statement. And so Mr. Jenkins is pointing out to Fujitsu and in turn you that in order to respond to Professor McLachen's interim report, the Post Office needed to obtain the underlying data. Yes?
Sorry, yes.
Do you know why the underlying data had not been obtained?
Well, certainly it's been requested. As I said, there's a process and a procedure within the contractual commercial relationship between the Post Office. I think some of the emails I think we looked at yesterday, that's been dealt with in the background, which I'm not copied into. And I think Mr. Jones, in turn, is dealing with somebody else within the Post Office with regards to that. And then,
So this is 3 minutes to 5 on a Friday with a court deadline of 4 o'clock on a Monday, with the Fujitsu employee saying, I can't answer these questions without sight of the underlying transaction data.
yes.
Yes?
Yes.
Let's go back in history, please. Poll 305 2202. If we scroll down, please. Thank you. Email from Mr. Longman to you of 6 months earlier. At the hearing on the 14th of July, the defence indicated they'll be seeking the services of a forensic accountant to analyse the Horizon data, as Miss Misra is now challenging the accuracy of Horizon. I have tried to obtain the data for the time Miss Misra was sub-postmaster, 3 years, But as you can see from the email from Dave Posnett, there are a number of issues. Can you advise council of these issues and inform me as to what action to take? We can look at the Dave Posnett email if you want, but so this is 6 months earlier, Mr. Longman raising with you, obtaining access to the underlying Horizon data.
Yes.
Why hadn't it been sorted out in the 6 months that elapsed?
Well, it's gone off my desk and landed on somebody else who can deal with it. It's not a lack of trying, it's the contractual commercial relationship and also the authorization and also as to obtaining of it. I mean, it's not something, this is something within my remit. If like I said to you yesterday, if it was up to me, then certainly I'm not concerned with the cost of it, because I'm as a prosecutor under a duty and obligation to provide it. And the simple answer would have been to say, look, you can't provide it, offer no evidence. I mean, that's probably where it would come to. And I think, as you could see David Posnett's concern, he's in a position whereby he's concerned with one aspect. You've got somebody else, the lawyers and the commercial and contract team, dealing with something else, and you've got somebody else who's in a position or role of requesting it. So I'm not sure. What are you asking me?
I'm asking you why you sent a request on at 4:30 on a Friday
To
Mr. Jenkins, essentially,
Well,
asking him to opine on Professor McLachen's third expert report. And he says, I need the underlying data.
yeah.
And it was known for 6 months that the underlying data was something that was necessary to obtain. I'm asking what had happened in the 6 months.
It
It had been passed around people's desks. Is that the answer?
No, the answer is it's going through the post office. I can honestly say that it works very slowly, but it's not like a commercial organisation where I've been concerned with in private practice. It's completely different way of dealing with it. I mean, certainly here, there's the processes, there's systems, there's contracts, there's commercial relationships. As a prosecutor, as a lawyer, you're basically in other people's hands.
Okay, anyway, let's
what
go
I've
back to the 5th of February 2010 then, 6 months on. FUJ 0015 2930. Email at 5:10 on the Friday. Jarnail, this is an email. So David Jones to you. Jarnail, this is an email I received earlier from Gareth. You'll see that he's clear that in order to answer council's questions about any issues, he needs to be able to check the underlying transaction logs to be able to say whether there were any issues. On the specific issues you raise, Gareth's view is, and then number 3. Remember what number 3 is about, Mr. Singh?
Yes.
Whether there are any known issues or problems with the Horizon system of which Fujitsu is aware. And he says, that's Mr. Jenkins, is not currently in a position to make a clear statement. It's possible for there to be problems where transactions have been lost in particular circumstances due to locking issues. When this happens, then we have events in the underlying eventing logs to indicate there was an issue. Whenever we provide transaction logs to the Post Office Limited, we check for such events. In the case of West Byfleet, we've not been asked to provide any transaction logs and so have not made these checks.
Yes.
Presumably you regarded that as a huge red flag.
Well, obviously, as I said to you earlier, I explained to you what the situation was. There were problems in the background which I wasn't aware of.
You're being made aware here
Yeah, by
by Fujitsu
David Jones, yes.
that they cannot say, they're not in a position to provide a clear statement as to whether there are problems with Horizon or not.
Yes.
As a prosecutor, does it get any more significant than that?
Well, no, but as I say...
What did you do?
I don't know. I mean, I haven't got the paperwork. I can only go by years on with what you've provided me with. I mean, I can't see what this is sort of, again, is another 5th of February. I mean, there's been lots of information going backwards and forwards trying to deal with it. So I can't answer that as to, well, obviously, you know, it's important, and I think we have emphasised it. And then like, subsequently, finally, I think we do get them, don't we, in March?
I mean, presumably, at the very least, this kind of communication is something that you would want to ensure goes on a disclosure schedule. Just at the very least.
Is it not on the final disclosures? Not on the one on...
so far as we can see, this
September.
information was not disclosed.
September 10.
Correct.
That's the final one. That's not on there. Do you know who actually signed that off?
I can check over lunch.
Okay, please do.
But at the, thank you very much. At the very least, you would want to ensure that this would go on a disclosure schedule,
Yes,
wouldn't you?
essential. Yeah, agree.
Did you say essential?
Of course. Well, you know, yes.
The operators of the system are saying
Yeah.
they can't make a statement,
Because
a clear statement, that there are no problems with Horizon
yes,
or known issues with Horizon.
obviously there's confusion, there's mistakes, there's errors, all sorts of things going here. But it's a big organisation. How do you control it?
So I wonder whether we could stop there, please, and come back at 10 to 2. We're finishing at 3 p.m. today, and
Yeah.
so I think we can do one session after lunch from 10 to 2 until 3 p.m. I informed the call participants who had submitted questions that the progress that I've made isn't as swift as I'd intended for one reason or another, and therefore I would propose that I continue asking questions until 3 p.m, that they defer any questions that they wish to ask of Mr. Singh until when he returns on the next occasion next year. Everyone, I think, has been agreeable to that.
And any questions that you may still have will also be dealt with next year. Is that right, Mr. Yeah?
Yes, exactly. I'm afraid it's taken me longer than I'd hoped.
No, I follow. And could I just have confirmation from all the co-participants that they're content with that?
Yes, there's lots of nodding.
Good. All right. So we'll break off until 10 to 2, and then we'll go till 3 o'clock, or obviously a minute or two beyond if you want to complete some particular line of questioning, and then we'll resume in the new year.
Thank you very much, sir.